Good morning, and thank you for this time. I want to go into my career just a little bit. I've been a police officer for 21 years, going into that 2 years in corrections as well, holding the rank of sergeant as a police officer. Throughout my career in both Washington and Oregon, I've taken 8 polygraphs. I've been overseas for 2 years with Department of State and DynCorp, had a secret clearance. I also spent 6 years in the Coast Guard with a secret clearance. I've been an instructor throughout my law enforcement career in multiple different disciplines. And since this incident happened, I've passed a full state background check with Oregon DOC, as well as a federal background check with the VA Police Department with full disclosure of this incident. I want to get into first the allegations against untruthfulness. The comments that I made at the scene to Ms. Shippentauer that's listed in this was also a suspect and a victim at the time. So I made a ruse to her. I've done it throughout my career of using that as a tool to elicit more information, stating to her that I talked to 3 people at the other house and trying to see if her statement had changed or whatever, elicit more information. In that, when I was called later by Ms. Richards, who throughout my time with the Tribal Police Department, was informed when I first started there that she was not allowed in dispatch due to previous incidents of her giving suspect and victim information to people outside of investigations, and that she's also not an employee of the police department. She actually belongs to the prosecutor's office, where she is a victim's advocate, no legal authority in any way, shape, or form of that, not part of investigations. So the night that she called me, she'd gotten text from Ms. Shippentauer and was listening information for that investigation, which we had not fully concluded yet. So with the previous history in mind, I told her exactly what I said to Ms. Shippentauer at the scene, of that I contacted 3 people and they had a different story, and then went into why we didn't make a mandatory arrest on the order, which I'll get into next. So that was the comments made to Ms. Richards, and that they said I was dishonest with, as well as to Ms. Shippentauer, who at the time was a suspect and a victim in this. As far as the order goes, the mandatory order, when I got there, Ms. Monahan as well as Ms. Shippentauer both stated that the order was over, it was done. They knew the judge that did it, that signed it, all this. Ms. Shippentauer, even in extremely intoxicated state, knew all the details of this order. And so when I talked with dispatch, Mr. Almond, she said that she confirmed the order over the radio, but then said it was a non-expiring order. To me, I've never heard of that in my entire time. And so with that, I had some reservations on that. I asked her what the expiration date was written on there. She said there was nothing written and that there was only 1 page in the folder, which again was a red flag to me. So I erred on the side of caution to not violate any rights and do more investigation into this matter. So I advised the parties. They're saying it's confirmed, but I have some reservations on this and I want to get to the bottom of it before I do anything else. When I got back to the station, I saw that there was only 1 page. It wasn't signed. And with that, both things were sent to the court to get more information. The next day when I came in, I got everything from the court that said, yep, it was still a valid order. And so I immediately went into the prosecutor's office and talked with our prosecutor and said, hey, this is what happened last night. This is where we're at. It's a valid order. How do you want me to proceed? And he said, don't take any enforcement actions and chalk it up as a lesson learned. I was done right then and there with the order part of it. And then as far as the menacing call with Tukwila, very violent city, been there several years in my career, been to a lot of gun calls. And when I got there and started talking with her, with Ms. Shippentauer, she couldn't tell me anything about the gun. She just said it was a rifle. She couldn't tell me anything of what it looked like or anything like that. And then made a comment of, well, aren't you just going to go search his house like you did mine? Referencing a previous call, which I won't get into because I don't have the time.
Go to the timeline. Met with Holt on the
And really quick on this, on that same day that I met with the prosecutor's office, Sergeant Holt was acting chief. I went in, had a discussion with him, and he stated that I was wrong in what I was doing. And then also Detective Barnett was out at a conference and had him, the first thing he did was had him investigate me rather than send anybody back out to that reference, that call, to investigate anything further.
Okay, your time is up. Thank you, Mr. Daughtry.
Yep.
We will now ask for a consensus to adopt the record as has been presented to us, or return it to staff for additional information is needed. Does anyone have concerns about the record that we have? So I'm looking for a consensus.
Rob Wood for the record, this is just minuscule, but there was an error that was changed by staff. Has that been put into the record that we will be adopting? It was a reversal of parties, if I remember correctly.
Kathy McAlpin for the record. On page 1 of the staff report, the last sentence where the statement is for report that someone person 2, it is person 1. Rob did get a hold of us and call that, and we confirmed it should say person 1. So yes, that will be corrected in the final report. But for this copies that went out long before that, no, your copies don't reflect that it is person 1 on the last sentence of page 1.
And Robert, for the record, also probably not material, but on page 8, exhibit AA 3 of 12, the top paragraph, I believe, contains an error. 4th line down. It says the felon had a mandatory arrest protection order against him. I think that's incorrect. I think he was a protected party.
AA, what page, Rob?
3 of 12.
And we do have a question from Christopher Doherty.
They're not allowed to interact. Yeah, Chair, Kathy McAlpin for the record. Again, that was, it's not our document that was presented, but in discussions with Member Wood, I think we saw the same thing. It's just not our document to correct, but I believe that is correct and should be noted for the record, so thank you.
Any other concerns about thank you for bringing that up. Any other concerns about the record, or do we have a consensus to adopt the record as presented with the corrections? Okay, I don't see any objections. We can open the case for discussion. Remember to state your name and identify any aggravating or mitigating factors. The first thing we're talking about is aggravating or mitigating factors in this case. We'll open it up. We can not talk over each other, it'd be helpful also.
Barry Rowan for the record. I offer as mitigating the fact that Mr. Doherty is involved and provided the statement to the board.
Rob Wood for the record. I think the supplemental information that we received, letters of support are great mitigating, and I also think the reasons or explanations for his actions are plausible. I think that's a mitigating factor. The one that isn't is the misstatement to the advocate, which he's taken ownership of. He's taken ownership of saying 3 people stated there was no rifle involved when it was only 1.
Any other aggravating or mitigating factors to discuss in this case? Hearing none, whenever you're ready, Melissa, if you just want to recap, make sure we have them.
One moment. As mitigating factors, I have that the committee identified that he participated in the review and gave a mitigating statement to the committee, and also as mitigating that the letters of support he provided were mitigating. His explanation of the events were plausible. He took responsibility for his statement to the victim advocate as well. And then I didn't hear any aggravating statements or factors.
We'll now open the discussion for the moral fitness violations. There has been 3 dishonesty, misuse of authority, and misconduct, all identified, which are obviously in the packet. We will need to have a discussion and either affirm, accept the recommendation as it is, modify, or negate, or we can remove them all. So now's the time we have discussion. I'll open this up. This does seem like somewhat of isolated incidents. It doesn't seem like a pattern of untruthfulness or misuse of the position, but this particular incident is concerning of the potential for serious consequences, which we're outlining here. Obviously, protective orders and things are in place for a reason, and when law enforcement comes, when we became aware and confirmed that it was valid, we're required to act. That's no different than a warrant. You confirm it, you act on it. So, but I do see this is more like, it seems to be isolated rather than kind of a pattern some of the other cases we've seen.
So Chair, just for clarification, Captain Calvin, for the record, are you offering some additional mitigation, or are you segueing into, are you recommending an affirming, modifying, or negating?
As I was talking about that, I was like, well, I almost sound like I'm mitigating. Yes, you're right. Yeah, I wasn't ready to make a recommendation to affirm, modify, or negate yet. I was trying to get some conversation going. I guess it's a very shy crowd today.
Yeah.
So do you think we should hear some thoughts on?
I guess Kevin Dresser, for the record too, one thing that brought up, as a detective, I'm not doing these as often, reference to the order being just a simple page and not being specific to an expiration date. I don't know if that's often the case. I mean, obviously it's valid unless otherwise, but the fact that it didn't include the specifics on an expiration date, or the opposite, that it didn't have an expiration date, might be somewhat of a factor to be checked into.
Again, we almost sound like we're mitigating. So,
Chair, I do believe that is another possible mitigation from Member Dresser, so duly noted.
Michelle Duncan, for the record. I think he's not denying that he was dishonest to the victim/suspect. And even the victim's advocate, he offers reasons for that. Some of those, depending on your interpretation, would be okay under the law. I think the issue of whether he acted on an order doesn't have anything to do with dishonesty. He also offered explanation for the reasons on that, and in the orders that I've seen, there are signatures and things, and you may at the most in that respect say that he didn't do his duties that he should have, but it's not that portion of it I wouldn't see as a dishonesty issue. He's not denying that he was dishonest. He's just saying that he had a viable reason to do so.
Barrett, for the record, as a continuation to what Sheriff said, he hinted and used the term ruse. It's a tactic that he uses, which I think covers at least half of what staff has identified as a dishonesty component, which is the victim and the suspect. repeating that to the victim advocate, that could be, why not be honest with them? But maybe that's something that they have internally. But I would say to the second part with the misconduct of not following through on the order, it sounds like the following day he went and did some due diligence to look into it to see if it was a valid order or not, and to include a conversation with the district attorney's office, and he was told to cease and desist at that point. So there wasn't a significant delay, I don't think, with regards to the investigation. Some agencies have the luxury of calling a 24/7, 365 agency to verify if it's legit. I don't know if Umatilla has that resource in play to where the next day would have been the viable option. So I think I'm in line with Sheriff that we don't have dishonesty, and based on your interpretation with the order, I would say we might not have misconduct or misuse either.
Other discussion or a motion to affirm, modify, or negate any or all of the findings?
For the record, I'll just add on the misuse of authority, under the conscious bias piece of this, he did articulate prior contacts with these individuals that likely played into his ultimate decision making. So I don't know if I feel quite as strong as that he consciously acted with bias. Maybe something lesser than that.
Daniel, for the record, I think that there is certainly an awful lot of information here. I just don't think that we're quite clear enough on each one of those to come to a conclusion that he is in violation of each one of those: dishonesty, misuse of authority, or misconduct. It's a messy investigation, and there's a lot of pieces and parts to this. A lot of us, I think, would be quite uncomfortable with how it played itself out. But as far as the moral violations, I just don't see it.
Okay. Is that a motion to negate?
I would make a motion to negate.
Okay. I'm just hearing, everything I'm hearing is mitigation and.
And just to be clear, are you negating all three is what I'm hearing?
Yes, I'll move to negate all three.
Kevin Dresser, for the record, I'll second that.
All right, we are voting on a motion to negate all of the moral fitness violations that were presented. Chair Downey.
Aye.
Vice Chair Cotting.
Aye.
Committee Member Anderson.
Aye.
Committee Member Barrett.
Aye.
Committee Member Daniel.
Aye.
Committee Member Jovic.
Aye.
Committee Member Dresser.
Aye.
Committee Member Duncan.
Aye.
Committee Member Livingston.
Aye.
Committee Member Lofgren.
Aye.
Committee Member Rowan.
Aye.
Committee Member Townsend.
Aye.
And Committee Member Wood.
Aye.
Motion passed.
Mr. Josh, did you leave, Mr. Gottry? Or are you still here? Seems like you left. Okay.
Still here.
Okay. We're concluded with your case.
Thank you, sir. And thank you to everybody.
Bye-bye.
Thank you, everyone. Have a good morning.
Okay. Melissa, this time I will let you do the case first.
Oh, okay.
They have like color-coded instructions for me, I still can't follow. You could put them in crayon, it would be really nice if Robbie's pictures.
That's why I do it. It's more fun.
No, it just says that you accepted it.
You want to swipe or?
I'm Scotty fan.
I think we have, I think all three of
Yeah,
yours
it
were
just
Brad
pops
Chase,
up.
is that?
Okay.
Oh,
Or do we need to get, we have somebody that needs to get out of here?
Let's focus on
Yes.
Did I
So
do
put one, or,
Which one were you in now? Shut up.
Okay, so Melissa,
Yes.
I'm going to explain the rules to the person.
Okay.
Then I'm going to turn it over to you, right?
Great.
Okay.
Sounds great.
I think I did something backwards last time. It seemed wonky.
Yes.
But you handled it perfectly. Cheers.
Oh, jeez.
I don't know. But it's fine.
One.
then they stop speaking and then they don't stop. And there's like this. So we need like a card that says.
Right, I wish that you could put the camera on.
Present, you can see it, I'm interested
I
in
know, I wish it
It's
was
just-
coming so I can hold it up.
I'm gonna start calling on people.
But maybe since she.
I'm gonna start
does
calling on
things,
people.
It will.
So those of you who are
She'll
hiding,
go in front of one of us, I can.
That's
Like,
true,
first
too.
week, and I
But
can-
try it out.
we're expecting big things.
It's like years. Just trying to prove, so. Forget what I
We're
said.
expecting big things.
Don't give
But in the
them.
future.
Yeah, I'm just thinking if they can't see it, we have to do something.
Good morning, Mr. Chase. My name is Scotty Nowing. I'm the chair of the Police Policy Committee. This is the time for us to discuss your case. After the case is presented, you'll be giving 5 minutes to provide a mitigation statement. Only 5 minutes. We'll stop you at 5 minutes. There'll be a timer down there. At the end of your statement, you won't be able to ask us any questions, and we won't be able to ask you any questions. While we discuss the case, if you want to sit there, that's fine, or if you'd like to take a chair on the side, that's fine as well. And when we're done, you can leave out the side door. Thank you. Listen.
Thank you, Mr. Chair. Melissa Langacho for the record. The department opened a professional standards case for Mark Chase to review the circumstances of his termination from the Jervis Police Department following an investigation by an independent investigator and a vote from City Council. The investigation found that Chase violated policies for harassment, discrimination, and retaliation. The department reviewed the records related to the separation and found conduct that met the Oregon Administrative Rule definition for moral fitness violations for misconduct. The department found that Chase threatened another person during a training event when he pointed a loaded firearm at an employee's face. And additionally, that he intentionally subjected women officers to sexually suggestive comments and harassment to test them, made scheduled changes following protective leave, and made gender-based statements about women. The conduct represented a pattern of intentional discriminatory conduct. The department is seeking a vote to affirm, modify, or negate the department's findings. Mr. Chase submitted written mitigation and is here to provide a verbal statement. When you're ready, we'll start a timer for you to keep track. Mr. Chase.
Oh, just go ahead and start?
Yep.
Okay. My name is Mark Chase. I proudly served for 4 decades in law enforcement, earning a reputation built on integrity, professionalism, and a staunch dedication for the safety and well-being of my community. My disciplinary record is a testament to these values, virtually free from any allegations of racial bias, sexual harassment, misogyny, or any retaliatory behavior until October of 2023. At that time, I was placed on leave, followed by my unjust dismissal in February of 2024. The false accusations brought up again were largely by 2 former employees who were described as disgruntled by former city manager Susie Marson, who served the city for 14 years. She oversaw the previous investigation and the complaints. She is here to support my moral fitness. The executive report indicates false allegations were not refuted, when in fact they had been, by a previous licensed investigator. Those decisions were considered proper, appropriate, handled administratively, or unfounded with no disciplinary action. This was done in consultation with CIS and legal advisors, yet they resurfaced as unsubstantiated assumptions of perceptions and distorted rumors. This report wrongfully casts a shadow over my certification despite my strong ethical record and community support. I own up to my mistakes, and as I have to a singular lapse in judgment. I took full responsibility of this mistake and worked with the safety officer to implement safeguards to prevent future issues. The reinvestigation that preceded my dismissal was not accurate, neither fair nor thorough. It violated the DPST Investigators Code of Conduct, the Oregon Administrative Rules, constitutional protections, and the Jervis Policy and Procedures, and it was conducted by an unlicensed investigator. This report relied heavily on false hearsay, presented unsupported claims as facts, ignoring crucial context. The investigator failed to interview relevant witnesses, current employees, including women, minority female colleagues, or my administrative aide, who all could attest to my fair, professional, and ethical conduct. No attempt was made to examine video evidence that would have provided an accurate portrayal of events. When I finally had the opportunity to speak to the investigator, they refused to provide Garrity rights. My attorney chose to end the interview due to the lack of basic fundamental constitutional protections, and this decision was mischaracterized as my refusal to cooperate. I've always been willing to cooperate. I was removed from my position because I refused to allow the police department to be used as a political weapon. My refusal to compromise ethical principles and violate my oath put me at odds with the city council and mayor who pressured me in a number of ways to act, extending beyond their chartered authority. This is just not my perspective. Jervis had 3 city managers in less than 6 months, including myself. 3 of 6 officers have left, and 1 is currently in the process of leaving. The entire former City Hall staff has left or was also unjustly dismissed, like Abby Fernandez, our court clerk for 4 years, who was here present to support my moral fitness. My dismissal was politically motivated and a consequence of my stand for ethical law enforcement and not a reflection of my misconduct. I have extensive community support, letters of reference from Jervis leaders, residents, and very importantly, a unanimous letter of support from the Jervis Police Association. I have several awards, including Officer of the Year, Chamber of Commerce Junior First Citizen, and in 2022, the DARE International Executive of the Year. All show my entire career and conduct have been discredited or have been dedicated to the highest ethical ideals and professional standards. My moral fitness is further evidenced by the recent recall of the city officials responsible for my dismissal, a decision that reflects the community's trust in my integrity and ethical disposition required for meeting DPSST's moral fitness standards, as well as their rejection of the campaign to discredit me and the hostile work environment they did create for staff. I take full responsibility when I fall short. I share those experiences so others can learn, and I am not the person betrayed in that report. I'm very willing to answer questions today, but since this is not allowed, I respectfully ask you to be fair and consistent. In reviewing the record as a whole, I believe a reasonable decision would consider the whole entire evidence gathered and the conclusions from the previous investigation, showing there's no substantial reason to determine a moral fitness violation and due process was not followed and my rights were violated. Please recognize my exemplary record by the mitigating evidence presented of my sound moral fitness and service for what they truly are and what they have been for the last 40 years. I respectfully request no action be taken against my certification as I have been wrongfully accused. Any sanction would adversely affect my employment options, ability to run my business, and continue as an investigator.
We have to stop you, thank you. Okay, we'll now ask for a consensus for the committee to adopt the record, return it to the staff for if additional information is needed. Just need a consensus on this. Is the record complete enough for us? Do we have any comments about that? Seen a lot of thumbs up. Okay, I'm gonna confirm there's a consensus to adopt the record. Any objections? Hearing none. We'll now have discussion on aggravating and mitigating factors involving this case. Open that for discussion.
Daniel, for the record, there are a number of mitigating letters that have been submitted for the record, as well as his appearance here today. Consider that mitigating.
Thank you.
I would, Terry Rowan for the record, I would echo what was just said, the 16 letters and the chief's presence and his written mitigation. I would also add that this appears to, part of this appears to have already been investigated, and Chief Chase was found not liable. And you know, what got me about this case, and I guess it would be mitigating as well, is that it does not appear that the chief was given due process. He wasn't afforded the opportunity to review the statements and comments made by his subordinate staffs, and I just found that awkward, I guess, as I was reviewing it. You know, there were those mitigating letters were from professionals that he worked directly with, including school officials. The the police association. That one kind of really got me. If it was if the morale there was that bad, I don't believe that they would have written that letter. I'm not sure why the investigator chose not to provide Garrity, especially in walking into waters where the person he's interviewing doesn't have a full picture of what he's being accused of. And lastly, as he has today, including in his mitigating letter, he's taking ownership for the mistake or mistakes that he has made. And those mistakes, I'm not sure I could find any moral fitness issues.
Public Member Lofgren, I would just have to say I totally agree with the last two speakers. Having read the documents, when I came to the number and variety of letters of recommendation, I found it difficult not to believe that mitigation was in order.
Thank you. Chair Nowing, for the record. Also, it did seem as this investigation went on, when he did exercise his constitutional rights, when they would not give him Garrity so you don't have to speak, it seemed like that was a turning point. And it kept being brought up that he didn't answer some questions, but then even as a police officer, he has the right to do that. So that, to me, it was mitigating in the fact that it seemed that maybe there was some sort of retaliatory effect of his actions and how the rest of the investigation went.
Rob Wood, for the record, I too came to the conclusion, reading the investigator's narrative, which typically we see questions and answers, a narrative with the last sentence says, I find Chase did this, I find Chase did that, when there's no second side of the story as he gave his mitigating statement. It just seemed, like everyone else has said, very lopsided investigation. Not complete, incomplete.
Michelle Duncan, for the record. I would agree with all the mitigating. I would say his supervisory authority would be an aggravating factor. However, that's if you substantiate what was in the investigation, which I agree that is hard to do in that investigation. There were things that could have been brought out that weren't. I think some things that could have even proved whether statements were true or not, like specifically, I didn't see anywhere where body camera was brought to light on the one incident where the female was making an arrest and said that certain comments were made in her presence. There just wasn't enough evidence in this investigation to prove most of those allegations that were in it.
And Kevin Dresser, for the record, I would agree. It seemed like the investigator, at the end of all of his statements, leaned on the fact that the chief didn't make a statement based on advice of counsel. He kind of made that as a factor of why the allegations were true. That's kind of how he ended each one, saying he didn't have that. It just seemed and read in the way I read it, that he was using that as like a fact to support the allegation.
I think we kind of bled into maybe, which is good. It's good discussion, yeah. But yeah, so I want to keep it going, but just make sure that we're identifying mitigating. But I do think we've kind of bled into kind of the heart of the issue. Is this more than a misconduct here? But is this actual misconduct? So we'll keep all that in mind when we ask the next question. Any more aggravating or mitigating?
Okay, Rob Wood, for the record, there is an aggravating situation that really turned my stomach as a firearms instructor. Although there's mitigating against that as well, is that pointing a loaded firearm at someone's face. Everyone knows in law enforcement, basic training, all advanced training, you never, ever do that. And the statement was, my finger was off the trigger, so it was safe. That really bothers me. But then he has owned it. He's completely owned it. He met with people after the city council meeting, and he's right up front says, I shouldn't have done that. I made a big mistake. I don't know if it rises to the level of misconduct, which we'll talk about later, but I just wanted to get that on the record.
Teresa Livingston, for the record. I agree with everything that you just said, but the one part that did bother me, though, in listening to the video and then is that he also tried to put equal blame on the instructor, which I get it, because they are responsible for safety, but I had a problem with that part. It was almost like I'm gonna take responsibility, but it's kind of like that but answer and trying to push it off on someone else as well.
Thank you. Scotty, down the record, also aggravating with that situation was, he said, well, we're a police officer, we point guns at people all the time. Well, anyone you point a gun at, we all know, you better have a good reason to point a gun at them, it better be justifiable. So we're just going around pointing guns at people willy-nilly. So I think that was, to have that mindset is aggravating to that situation, both parts of it. I agree with you also.
Shannon Anderson, I also see as mitigating that even if I make a mistake and I take ownership of it, I'm still looking at how do I prevent it from happening again, and how might I have somebody else not do it where it could lead to a tragic incident. If we get lucky once, it could lead to a tragic incident another time. And so I understand that taking that responsibility piece. I think it's okay to think about other causes and reasons so that we can prevent things.
Any other aggravating, mitigating? Melissa, did you have a chance to?
I think so.
Okay.
So please let me know if I missed something. I have as mitigating that the letters that he submitted, his appearance and his written mitigation were all mitigating factors. Some of the allegations were already investigated and he was found not liable. He was not afforded due process in his termination. The letter from the police association was particularly mitigating for the committee. He was not provided a Garrity warning and took responsibility for his mistakes. He had the right to not answer questions during the investigation, and that seemed to be held against him. The narrative in the investigation was lopsided when factual statements were made. His level of certifications would be aggravating if the allegations were substantiated, but there was not enough information. The investigator drew conclusions without having sufficient information. The pointing of, and then for aggravating, I have that the pointing of the firearm was substantiated, and but he did take ownership of the conduct. He tried to put equal blame on the instructor in the incident with the firearm. When pointing a firearm, he should have been ready to use it. The same situation could have resulted in a tragic accident if repeated in the future, Mr. Chair.
Michelle Duncan, for the record, I'd add that in all those instances, he had supervisory authority, even in the training instance. That's an aggravating.
Looking for a consensus that to cover issues we brought up. Okay, we will open discussion about whether there is a moral fitness violation. Here we're looking at misconduct, and it's essentially two kind of different parts. The firearms part is on its own, and then kind of a pattern of other ones. We can open discussion on that. We can affirm, which is accepted as it is, modify it, negate, remove it all the way. I'd love to hear some discussion. I think we've already had some, but.
Teresa Livingston, for the record, I know it was brought up in the past section with the aggravated and mitigating, but I was bothered. I actually put a red mark and a question mark for the body worn camera. They mentioned the body worn camera, but we weren't able to view that, or it doesn't seem like it was even reviewed by the investigator, like an opinion on whether that occurred or didn't occur, or how it occurred, or what. So that part really kind of bothered me, that wasn't thoroughly vetted on that part of the investigation.
then
To make a
designate-
proper decision, sorry.
Forgive me.
Designate Jovic, you had your hand up.
Nope, pull it down. Answer my question. Thank you.
Perfect.
Terry Rowan for the record.
Go on, Terry.
You know, I just found, again, this lopsided report, and I've never, in all my years of public safety in many aspects, I've never seen, it seems like almost in every person that was interviewed, it ends with a statement, because Chase chose not to fully participate in a voluntary interview, I do not have his side of the story regarding these specific allegations. These allegations are therefore unrefuted. I've never seen that in any report in my career. And the information is taken at face value with really not much other supporting evidence. To say that this person is being completely truthful and it's unrefuted. And again, I go back to, it seems like some of these cases had already been investigated. I'm not sure which ones have been, but maybe if the city could bring some light to that, it may paint a completely different picture.
Thank you, Terry.
For the record, I too had the body worn camera comment written down, and I probably missed my vote for the accept the record, which probably should have been brought up at that point of whether or not we wanted staff to go back and ask for that, because that could have been an independent piece that doesn't have him or the other person attached to it. That could have been some, okay, there's some legitimacy to what's being said, that I would have needed to lean on without being able to get Chief's opinion and perspective on how that stuff happened. I don't know if staff can answer whether or not they've tried to get that. Is that too late?
Melissa Langbasher for the record. We did try and get that information, but our request did not receive a response. If the committee wants us to keep trying to get that information, I can definitely do that.
Thoughts?
Because for the record, that would help to solidify one small piece of this, which potentially then could lean into the other parts of the conversation. But I don't know that I need it to move forward.
Other discussions or motions to affirm, modify, or negate?
Michelle Duncan for the record. I just wanted to say that I don't know if even we had the body camera footage confirming what was stated. The rest of this report that relies on that particular area of harassment, and there is so much subjective feeling of retaliation and feeling of harassment with very little substantive. That would be the only piece that we could even prove. So I don't even know if it would, like, the pregnancy leave and the intention of the pregnancy leave or schedule change. I don't know that has any bearing on any of that portion of this investigation. I think the investigation overall was poorly done and very slanted. So we might have one piece that he made it, some comments that were inappropriate, but I don't know that would weigh that heavily on a decision here today.
Shannon Anderson, I have a question. It might just be how this is outlined, because it seems like almost two different reports and how they're formatted and written. Do we have the first report that cleared of the conduct?
Melissa Langbasher for the record. That was not provided when we asked for the records related to his separation, and I'm not sure that the investigator looked at it either, but if the committee wants to send the case back for the department to request additional information, that would be something I could request.
Rob Wood for the record. I would mirror Member Barrett's, I'm not sure that would help, because that would just further solidify, I think, the direction we're going. Retain that.
Terry Rowan for the record. I would tend to agree with that. It's just, it just has the bad feel all the way around. And I don't think gaining more information, if the investigator was privy to, I think he said something like 100 and some pages of information, why wasn't it incorporated into this? And that should be one of the first tasks that the investigator, put into his report, or at least mention some of the findings in those other reports. That leads me to believe that maybe they didn't want it to come out and kind of muddy the waters, I guess you could say.
Thank you, Terry. Superintendent Connie.
Connie, for the record, I was just gonna make a motion to remove or modify the second half of misconduct. Leave the pointing of firearm at another person, which has been discussed and has its own set of mitigation, but just move forward, removing the second half.
Barrett, I would second that.
All right, we are voting on a motion to modify the moral fitness violations as discussed. Chair Nowning.
Aye.
Vice Chair Cotting.
Aye.
Committee Member Anderson.
Aye.
Committee Member Barrett.
Aye.
Committee Member Daniel.
Aye.
Committee Member Jovic.
Aye.
Committee Member Dresser.
Aye.
Committee Member Duncan.
Aye.
Committee Member Livingston.
Aye.
Committee Member Lofgren.
Aye.
Committee Member Rowan.
Aye.
Committee Member Townsend. Aye. And Committee Member White.
Aye.
Motion passed.
Thank you. Okay, so now, I believe we're left now with affirming the first part of misconduct, where just the part with the weapon.
Shannon Anderson, are we able to still discuss that part?
I believe we can.
Okay. Threatened. So there was an incident and it happened and a life could have been taken in a tragic incident. It's hard to say though that they were threats or threatened. It was, it's one of those safety violations, but the purposefulness of it and the threats I'm struggling to find.
Barrett, for the record, a better word may have been endangered.
I would agree with that.
Can I make a motion to modify that part of the wording of it, or?
Chair, you can. I mean, I think also, if I'm hearing the tone and tenor of this, you can also, somebody can make a recommendation, think it's a performance thing only. You can also say that while you see that, and as a potential, you can take no action. So you have a couple of tools, and however we can help navigate and clarify anything. And Melissa, I don't know if I cut you off, if there's something else you'd like to add, feel free to do so.
So Shannon Anderson, maybe what I'm trying to say when I'm uncomfortable with the word threatened is that I see this as a performance violation and not a purposeful misconduct. Or I have question about that.
Robert, for the record, so pointing a firearm at someone is considered a high-level use of force. It needs to be appropriate, intentional, and legal. And I think in this case it was intentional. It just wasn't appropriate nor legal. So I think it needs, in my opinion, we can change the wording. It needs to be left in here, but a second discussion of whether we take action or not.
I, for the record, I agree with Member Wood. I think this case, based off some of the aggravating pieces to this piece, I would be inclined to leave it in the record, and then we can talk about whether or not it's appropriate to take action.
Daniel, for the record, I would concur with Superintendent Cotton.
Do we want to leave it in as it's written, or do we modify the wording? Or can we not modify?
I don't, Chair, Councilman Kaufman, for the record, I don't think it's necessary that you need to modify the wording. We're capturing that. And that you do, the intent has been, and I think it was passed by consensus, that you wanted to modify to keep it in there. I think where you're gonna hear the rest of it is what you decide to do after that. And just want to phone one friend, my rule.
Certainly.
Thank you.
So for the record, Jennifer Howell, the definition of misconduct states misconduct includes conduct that violates criminal laws, conduct that threatens or harms persons, property, or the efficient operations of any agency, or discriminatory conduct. So if you find that the conduct threatens or harms persons, that meets the definition of misconduct, and you choose whether or not it's actionable.
Thank you, Jennifer.
Okay, I'm gonna take a leap, Rob Wood, for the record. I make a motion that we leave it in as misconduct and we take no action.
Audio second.
All right, we are voting on a motion to affirm the modified moral fitness violation as discussed and then take no action. Chair Nowning?
Aye.
Vice Chair Cotting?
Aye.
Committee Member Anderson?
Aye.
Committee Member Barrett?
Aye.
Committee Member Daniel?
Aye.
Committee Member Jovic?
Aye.
Committee Member Dresser?
Aye.
Committee Member Duncan?
Aye.
Committee Member Livingston?
Aye.
Committee Member Lofgren?
Aye.
Committee Member Rowan?
Aye.
Committee Member Townsend?
Aye.
And Committee Member Wood.
Aye.
Motion passed.
Thank you for saying that. I forgot. Even wrote that in there. I forgot it.
We're about halfway through. Does anyone need a 5-minute break? Anyone need a 5-minute break? Good to go. One more?
Chair, we have 2 more people in person. Again, in the hallway as well.
Okay, and Troy Gaynor, I think, is next, correct?
Book 2 and 3.
Yes, I agree.
I think it works for that, but they were taking no action, you know.
Yeah, with the,
Yeah.
Just next year, see the right discussion.
Oh, thanks.
Good gracious.
I felt like I was feeling like so safe.
Good job.
Oh, yeah. Just, it's okay. Just, you just, hopefully.
If you're ready, Chair Nowning for the record. Mr. Gaynor, my name is Scotty Nowning. I'm the Chair of the Policy Committee. After your case is presented, you'll be given 5 minutes to provide a mitigation statement. 5 minutes will be timed and we'll cut you off at the end of the 5 minutes. You will not be able to ask us any questions and we can't ask you any questions. Once you're done and we're discussing the case, you feel free to sit there if you want, or if you want to sit in one of the back chairs with your counsel, that's okay as well. When we're done with the case, you can exit out the side door. Okay.
Thank you, Mr. Chair. Melissa Lane Botcher for the record. The department opened a professional standards case for Troy Gaynor to review the circumstances of his termination from the Scappoose Police Department, which was based on his indictment for 9 counts of official misconduct, 3 counts of delivery of oxycodone, and 1 count of tampering with evidence. Gaynor took his termination to arbitration and an arbitrator reinstated him to employment. after finding that the conduct did not fall within the jurisdiction of the collective bargaining agreement. The arbitrator did find that Gaynor mishandled prescription drug evidence in a criminal case and that he received pain pills without prescription. The department presented Gaynor's case to the committee in August 2023 to review the circumstances of his separation from employment, and the committee requested to postpone the review until the conclusion of his criminal case. Mr. Gaynor was acquitted of all of the charges in his criminal case, and the department reviewed the information related to his separation and criminal charges, determining that there was conduct that met the OER definition of moral fitness violations for misconduct. The department found that Gaynor, his destruction of evidence in a criminal case created an inefficient operation of the prosecutor's office that was handling the criminal case, and that he solicited prescription pain medication from a community member and accepted their medication. His solicitation created an inefficient operation of the Scappoose Police Department by damaging the agency's position of trust in the community and with local law enforcement. The department is seeking a vote to affirm, modify, or negate the department's findings. Mr. Gaynor submitted written mitigation, which included information from the committee's, Mr. Gaynor submitted written mitigation and is here to provide a verbal statement to the committee. Mr. Gaynor, when you're ready, we have a timer that will start when you begin speaking.
Thank you for the opportunity to speak to you today. These are just some notes to keep me on track and so that I don't ramble up here, but they are my words and not prepared by anybody else or my attorney. First and foremost, I fully acknowledge and own up to the mistakes I have made, as I have always done throughout my career. Excuse me. And I'm not here to make any excuses for these mistakes. I do acknowledge and take full responsibility for my error in judgment when I accepted pain medication from 2 friends before or around 2018. My quality of life was severely hindered during this time due to a debilitating knee condition that was eventually corrected through surgery. The exchange of said medication never took place on duty or while in uniform, but regardless, I make no excuses for this behavior and recognize it should have never occurred. In 2021, I was finally eligible to undergo a full knee replacement due to no other corrective surgical options. My quality of life has improved immensely, and I have made a full recovery. Since undergoing this surgical procedure in 2021, I've never had or needed any pain medication for myself. I'm back to a great quality of life, both personally and professionally. At no time was this a situation of being addicted to pain medication or a situation needing a recovery program. I did make the mistake of not paying attention and destroyed evidence in a criminal case too early while serving as the evidence technician, thinking it was not needed due to what I had read at the time. This evidence was, though, taken to the incinerator and destroyed with the witness. All of these mistakes have been addressed by disciplinary action within the department, to include loss of pay and a formal disciplinary letter in my personnel file over 2.5 years ago, after the ruling from an arbitrator in May of 2022. I fully acknowledge and take responsibility for my mistakes, also affecting and embarrassing the city I work for, my co-workers in the department, our profession, and my family who has stayed by my side throughout the last 4 years. On October 14th of this year, I did return to the city of Scappoose as a full-time patrol officer. I am healthy and committed to serving the citizens of Scappoose as I have done for the past 20 years. Please allow me to prove to you I am a good officer and I have learned from my mistakes. I've dedicated to continuing to serve my department and the citizens for many more years. I ask that you please do not revoke my certification. Thank you for your time and opportunity to speak.
Okay, we're going to talk about adopting the voluminous record in this case. This will be by consensus, thumbs up if we have enough information included in this packet, or you want to have some discussion about other things you would like. Okay, seems we have a discussion. Any objection? Seems we have a consensus for that, to adopt the record. Okay, so we're gonna open up the case for aggravating and mitigating factors. Open up the case for discussion. Chair Downing, I'll start it. Mitigating, see, Mr. Gaynor is here today, took accountability for his, mistakes in the evidence or improperly following the evidence procedures and for improperly taking prescription medicine.
Member Townsend, some mitigating factors for me in my review is that it was unclear what the policies and procedures were about collecting evidence, where it would go next, collecting evidence, destroying evidence, and then also interacting with various agencies, how that would all go as well.
Teresa Livingston, for the record, a mitigating factor is that he is still currently employed with Scappoose and Patrol for that his agency.
Michelle Duncan, possible aggravating factor, but I want some clarification. In reading the investigation, he only admitted to taking prescription pills from one community member. In his testimony here, he just admitted that he had taken them from 2 community members. I think that inconsistent statement, possibly falsification in the investigation, is an aggravating factor.
Shannon Anderson, I concur. When I heard that, I thought maybe I missed something in my review. But I also recognize there was an allegation about individual A and individual B, and what I thought I read was that there was an admission to individual B, correct, but that individual A had not provided any.
It's kind of accurate. I think individual A changed their story. He originally said no, then yes, and then didn't remember exactly when or how much. So there is some.
Yes, but his statement said
Right.
he did not take it from individual A and did from individual B.
Additional aggravating or mitigating factors.
Shannon Anderson, potentially mitigating charges were dismissed in court.
For the record, there was an extensive audit done of the evidence room around this investigation. Mitigating is up to a certain point. He had no errors or issues with any of his property and evidence handling prior to, but at some point we started to see errors, which is when I would make that an aggravating, a change in behavior with all the other things that we kind of had in line. Do show a pattern, do show a trend. We have some admission that would support speculation with some evidence. I also would find aggravating that it appears that he was tested, is what I actually wrote down in the book. At some point here from one of the agencies that he would pick up from, she would put toys and magazines in a box and tape it up. Unless you're an evidence person, and this maybe goes to Member Townsend's comment about policies and procedures in place. I'm not going to open a box that has evidence tape and a signature and a seal on it. That's just not something that I've ever been taught to do, unless I'm going to court or I've checked it out or I have some kind of legitimate law enforcement purpose to do so. So I find that an aggravating thing is people were skeptical and testing it for their own verification of theories.
Michelle Duncan, for the record, also aggravating, kind of tagging on to that, is that he made statements that he received those packages but never unsealed anything. Secondarily aggravating is his reputation in the community, and specifically the community with law enforcement and neighboring agencies is clearly not in a good standing.
Anyone else? Thank you for the discussion. Whenever you're ready, Melissa, if you.
I think I'll start with the aggravating because I'm not entirely sure if I captured the delineation of the factors. This aggravating, I have that during the investigation, he admitted to taking prescriptions from one person. However, today he admitted that it was two persons. There was a change in his behavior and speculation that he was misusing prescription medications. People were skeptical of his behavior and tested him by putting objects in a sealed box, and he was not in a good standing in the community. For mitigating, I have that he is here today and took accountability for the mistakes that he's made. The policies and procedures around the drug take-back program were unclear. He's still employed with the Scappoose Police Department. The charges against him were dismissed. There was an audit of his work in the property room that found no errors prior to the change in his behavior, Mr. Chair.
Get a consensus that that was all of them, or did she leave anything out, or does anyone have anything to add? Good. Consensus.
Well, Robert, for the record, and I'm trying to find, I have a lot of marks in this, and this is messy, and I don't like a lot of this, but at one point, Gaynor was asked by Sergeant McGrew, in your, not including the drug take back, which you or did off duty, have you ever been in possession of narcotics not prescribed to you by a licensed physician, but to another person, meaning that the pills were subscribed to like somebody else? The answer was no. And I believe somewhere else, and this is what I'm trying to find, once that other person was identified, the answer changed. Please, someone else chime in if you remember where that was. Yeah, so that goes against, in my opinion, the testimony that as I've taken ownership of this, of accepting pain meds from someone else twice, which is concerning to me.
I don't know if this, Shannon Anderson, I don't know if this is the location that you were thinking that it was, but in the submission by the FOP on page 3 of 225, at the top it says Officer Gaynor admitted he accepted pills from Mr. B on one occasion but denied any other allegations. So it's at least in, it may be in multiple locations,
Okay.
what you pointed out.
And that's aggravating, what you're saying.
I'm agreeing with you, yes.
Yes.
Michelle Duncan, for the record, is there a potential, just listening to things in the room, that we're adding a dishonesty factor here?
I think, Captain Calvin, for the record, Sheriff, I think, based on what I heard your statement say is you're seeing an inconsistency with the testimony today given by Mr. Gaynor to what is in the written record, that you have some concerns that those are conflicting.
As well as the written record of, I didn't take prescription medications from anyone else, to I did.
Then yes. You could, then,
Make a motion to amend.
exactly, modify it and then add it, at least to continue further discussions.
Michelle Duncan, is that, oh wait.
Yeah.
Michelle Duncan, I would make a motion to add dishonesty as part of his, as part of the consideration today.
Let me just go back, thank you, Chair Gavin, for the record. Let me just go back and make sure that we're done on aggravating and mitigating. And I get that adding is going to be an aggravating factor, we just want to put that part to bed and follow the list. And then we'll go to the next, which we, I think we'll have an opportunity to modify the record.
And I may add, Captain Kaufman, for the record, Sheriff, for dishonesty, it has to be intentional. So if you feel it, based on what you've read and what you've heard today, that meets that, and you want to continue discussion, I just want to point out it has to be considered intentional dishonesty.
Okay, do we have a consensus that we've identified all the aggravating and mitigating factors? Thumbs up. Down? Any objections? Anything else?
Barrett, for the record, point of clarification, I thought I remembered reading the any Brady stuff in here that he was gonna be considered for testimony. Did I read that? Somebody, I don't remember any stuff. Thought I remembered reading that he was gonna be called as a witness, which would then be a mitigating circumstance against a dishonesty component. I'm failing to find that right now, so if somebody does know where that's at.
Actually, I have a similar collection too, so I'm trying to find that.
I think that was in the newer stuff. 'Cause that was something, we heard this case back in August, fair for the record, we heard this back in August of 2023. And we sent it back because we wanted to wait for the criminal case outcome and then any Brady results, and I thought that was provided.
I think it's 500 pages.
I know, that's why I'm not finding it.
588.
Barrett, for the record, to staff, do you remember that information being added in, or am I pulling that from somewhere else?
I am searching just as you
Okay.
are. I
Sorry.
vaguely feel like I recall that, but I'm trying to, nothing came up when I searched electronically, so I'm just trying to see if I can find it.
So in the conclusion, at the bottom of Mr. Cannell's, Daniel, for the record, at the bottom would be page 7, dated October 16th, 2024. The last page of Mr. Cannell's letter, under conclusion, it will be in the first sentence.
And Barrett, for the record, that reads, since the conclusion of the criminal trial, the Columbia County District Attorney has deemed Officer Gainer a credible witness and would call him to testify. I would add that as mitigating then.
Barry Rowan, for the record, I would add as mitigating the arbiter's decision.
Thank you, Terry. Anyone else? Aggravating and mitigating? Did you catch the last few?
I have as additional aggravating and mitigating that he was asked about taking medications, prescription medications without a prescription during the investigation, and he said no. Later changed that to one time when provided a cue, and today he said that he took prescription pills from 2 people. As mitigating, that he would be called to testify in court, and the arbitrator's decision.
Okay, Robert, for the record, I finally found it, so I'm going to substantiate my aggravating where he said no to the investigator about ever having in his possession pills that were not subscribed to him off duty like somebody else's. The answer was no. On page 71 of 98, Exhibit A7, he was asked kind of the same question, but I don't recall that. Captain Hall says, do you remember obtaining 4 or 5 pills from a person by the name of Redacted? Oh, that, yes. So I think I'm siding with down there. I think we might need to discuss adding a dishonesty moral fitness violation.
Okay.
Shannon Anderson, another mitigating factor for me was that it appears that other than the one agency, other agencies, once notified of this incident, did not, it was stated in the report that they didn't audit or look into things as well.
Scotty, I didn't quite understand that part.
Because, so, it didn't draw concern from other agencies is my mitigating factor.
Okay. Sense.
Michelle Duncan for the record, but I believe this whole started with Columbia County bringing up the concern, so it did draw concern from other agencies. Just not all of them for the same reason.
Yeah. Was the concern because of use, or was the concern the taking of prescription drugs from evidence?
I believe the initial complaint came from the sheriff himself, who saw him sweating and acting odd and said and saw a pill drop out of his pocket.
My takeaway was it was diversion was the concern. Diversion and subsequent use is what led to it.
Kevin Dresser for the record. I know it came up. Member Townsend had talked about the policy not being real clear about this whole thing. And there was a comment about the testing by putting children's books and stuff. But he had openly said, don't bother sealing. I'm compiling these and making it easier to transport them down there. And that didn't seem to be an issue necessarily by anybody saying, well, that's unusual. We shouldn't be doing that. At least I didn't read that. So it seems like he was very open. He's likely opening these up and somehow putting them all together just for easier transportation.
Michelle Duncan for the record, and it was a lot in here, but the way I recollected it is that they were saying he never asked them to unseal it. They chose at some point maybe not to seal it, because there was that discrepancy as well. But he testified that he never unsealed anything. He said that a lot of times in the evidence they would provide a bigger box, and he said, don't worry about the bigger box, that I just put it all in one box and send it in. But the individual smaller packaging was still sealed, according to some of these agencies as well. And this incident in particular, where they put comic books, she testified that it was sealed.
And that she, for the record, and that she confirmed that he unsealed it based on the fact that he found it humorous, I think is what she said. Correct. So he notified her that he did so. And for the record, I know that we mentioned, I think it was mitigating from the arbitrator. I think it should also be noted, though, that the arbitrator did recognize that there was still some mishandling of prescription drug evidence, but he did receive a number of pain pills, however, didn't have sufficient evidence to make a decision. So while I can see how some of that's mitigating, some of it's also aggravating, because they're also having the same conversation that we're having right now.
And Michelle Duncan, for the record, to add to that, is it looks like from the arbitrator's ruling, they specifically looked at what may or may not have happened within that contract time.
I just as a comment. When you look at diversion matters, this is obviously very concerning throughout this case. There are very concerning behaviors and actually policies. And, however, mitigating is he was acquitted. There was not enough in this case to land him criminal trouble. So it is very concerning, but I also struggle, even with today's discrepancy in testimony, with the timelines involved in this and his his testimony today that he admits to, you know, what led to this all potentially being a problem in the first place, which was a significantly injured knee, the need for pain mitigation, and how he got there, and his ownership that he was getting there outside of traditional methods prescribed. He admits to that. I think I may have a hard time going to intentional dishonesty even with the discrepancies based off of what's in this and what I heard today.
And Chair, Kathleen McAlpin, for the record, you actually have two options you can go. You can, again, modify and add dishonesty as its own moral fitness, or you can simply put it as an aggravating factor, that there was some consistency throughout in his testimony today, and you can call it out that way. So you do have two avenues to make a motion on and discuss.
Thank you. Okay, one last time for aggravating or mitigating. We'll move on from that. Appreciate all the discussion. This has been very robust discussion, important case. So can I get a consensus that, well, actually, let me let, if you can, the last few add-ons.
There were a couple, I'm not sure if they were aggravating or mitigating. So if you could help me, I guess, here. There was a concern, the concern was identified as the diversion and subsequent use, I think was a statement that Vice Chair Coddington has made. Was that something that you felt was aggravating or mitigating, or just a neutral statement of facts?
I think in the context of the other piece of that, which was the acquittal in the criminal case, I think it's mitigating.
Okay.
The other mitigating piece was the timelines and the fact that he's openly admitting to the cause, which was the injured knee, which led to, you know, potentially possessing and taking that in. And then when you factor that in with just the other aspects of this case and policy, just extremely concerning behavior surrounding this pill take back and other stuff. It's just that checks and balances weren't there, so I think that's mitigating.
Okay.
I think that the agencies involved there should have better procedures in place to prevent this, because diversion's a problem. We see it over.
The additional factors that I had recorded that the committee discussed were that in reviewing the records, there were concerns about his dishonesty or his honesty and truthfulness. Other agencies, as mitigating, I have other agencies did an audit, and there was not a concern from the additional agencies. And then as aggravating, one agency did have a concern with his taking of the drugs. As mitigating, I have that there was a concern. There were concerns with diversion and subsequent use, and that those issues in combination with the policy issues and a lack of check and balances and his admission to getting prescriptions outside the normal route for a medical condition, all that together was a mitigating circumstance. When agency put comic books into a sealed box, it did appear that he opened the box because he told the technician that it was humorous and that was an aggravating circumstance. But in other circumstances, it didn't appear that he was opening sealed boxes, only taking those unsealed boxes and combining things for an ease of transportation. And as aggravating, the arbitrator did find some conduct to be concerning, but was limited to the timeframe of the collective bargaining agreement. Mr. Chair.
Thank you. Okay, now we need a consensus on, did Melissa cover everything? We have aggravating, mitigating covered? How's that? Okay, looks like we have consensus. Any objection? Add anything? Afraid to ask. Okay, it seems we have a consensus. Okay, so we'll now open the discussion on the moral fitness violation categories. We've already had some discussion on that. There's been some discussion about potentially adding, or modifying, or potentially leaving it as is and having truthfulness be an aggravating factor.
For the record, I guess it's a question. When this case was brought to us back in August of 2023, dishonesty was originally one of the moral fitness violations. Why is it now not, based on staff's perspective?
Melissa and Gotcha, for the record, I think when we looked at that information again and considered other cases that we were bringing to the committee and those findings, that it appeared that it was more of a misstatement that he had made when he initially said no and then changed after he received a cue for the circumstance. That there wasn't enough to show that he was intentionally dishonest in those circumstances. And so that was taken off of the report.
Chair, Captain McAlpin, for the record, I just want to be clear and make sure that we didn't miss anything, especially with you, Sheriff. Did you actually make a motion to add, or were you seeking to clarify, could you? Just want to, if the motion was on the table, I think we either by giving you rule interpretation, I might have stopped it before we got a second, but I also want to recognize if there was an official motion on the floor that we didn't overlook that.
I guess some clarification. If I make the motion for dishonesty, is it something that then is up for discussion on that? We already did the aggravating and mitigating, I get it. But I think we need to open it up for more discussion. Does that make sense?
Yes, if you make the motion, the chair will then ask if there's further discussion before we get to a second, and we can go from there.
So I will make the motion for dishonesty based on the fact I can see where in the initial interview, the one time he maybe made made a mistake or miscommunication when he said no and then corrected it to yes. However, it's even more concerning to me now that he is, after emphatically saying no in the investigation, has now admitted today that there is a second person that he took pills from. Additionally, in the investigation, he talked about never unsealing the boxes that were given to him. However, on the one instance, we know that he definitely did.
Question, Shannon Anderson. Would this, if we were considering the testimony today as dishonesty, would it be on this, or would it be a new case that was needing to be opened because the misconduct was today during the testimony? Sorry.
Oh, Jennifer Howell, for the record. When you're reviewing the case, you get to consider it in its totality. So
This is just one factor.
So today was a totality of the entire case.
Okay.
Scott Hanford, I think that was one of the kind of the original pieces of the case. Is this one or two people? They interviewed two people, and so I think it does. We didn't ask the question; he offered it, and it's directly related to the case we're already considering. So,
And I would just offer on my motion is, again, we're now seeing multiple instances of inconsistencies in information of what he did or didn't do.
Shannon Anderson. I think that because we've seen it, we've had a discussion of it, we heard it today. For me, I think that adding it doesn't mean that we're having to take action. It just means that we're showing the citizens that we notice it, we see it, and we make decisions on it.
Probably for the record, I would agree with that, and I personally put less weight on the verbal mitigation with the slip up. I mean, we're nervous in front of people and it's possible that was a mistake. I put more weight on the transcription report, which is definite, clearly asked, not just did you. I mean, the question was expanded to the answer of no, to where it came back once a person was named, oh yes. Same thing with sealing and unsealing the boxes. It was a clear no until there was something presented. Well, did you do this on this date because this person said it? Oh, okay, I did. So that to me was more than the verbal mitigation given today with the inconsistencies. So I'm your member Anderson's. I propose also or second that we add that, and then whether we take action or not, that's a separate discussion.
So we have a motion to modify the record. We will add dishonesty. We have a motion and a second.
Alright, we are voting on a motion to modify the moral fitness violations as discussed to include dishonesty. Chair Nowning?
Aye.
Vice Chair Cotting?
Aye.
Committee Member Anderson?
Aye.
Committee Member Barrett?
Aye.
Committee Member Daniel?
Aye.
Committee Member Jovic?
Aye.
Committee Member Dresser?
Aye.
Committee Member Duncan?
Aye.
Committee Member Livingston?
Aye.
Committee Member Lofgren?
Aye.
Committee Member Rowan?
Aye.
Committee Member Townsend?
Aye.
And Committee Member Wood?
Aye.
Motion passed.
Shannon, I have a question. Because we've added this, are we able to talk about new mitigating and aggravating for this dishonesty piece?
Kathy McAlpin for the record. Yes, everything is still open for discussion. You've actually just added it to get to whether or not you think you will take action in part or any of the moral fitnesses that you've found to be in violation. So discussion is wide open.
All right, so Shannon Anderson, I'll start out what is in my mind, and I'm really having a tough time with. In regard to the statement during the interview, that sometimes, you're looking at an entire lifetime. There can be mistakes, and there's a reason that we give cues to clarify things. And so I'm giving a little bit of thought to that and where I stand on it. But today is something that typically is, there's an attorney, they review what you say, they review all of the things, and I'm struggling with, there's a few things that happened here. An attorney may have made an error that is affecting his client, and the client, there may be misstatements of fact and dishonesty happening at the same time, and it's just a lot to process all at once.
Michelle Duncan for the record. One, he stated in the beginning of his statement that this was his words and not his attorney's.
That's a good point.
Two, kind of going to what was said earlier about maybe this was held less weight on his testimony today. He came with a written prepared statement. And so, I don't have great eyes, so I couldn't see whether he had written on there were two people. But, he had that written prepared statement with him on his testimony, which was different than the two different versions that he had there. Additionally, on the sealed package, I don't recall that he was ever interviewed specifically or re-interviewed about that package with the toys and comic books in it. So I don't believe he ever changed his story to yes, I did, I guess is my point.
Chair Noni, I have a question. If we do take action on dishonesty, when would the date start? That's important to, this is a very historical situation. When will the date start?
It would be based on the date of the board's review, Mr. Chair, because he's currently employed in public safety.
So it's beginning today?
The board.
Oh, the board,
Mhm.
not even beginning today, right?
Comment for the record, I will just bring up again. I'm not refuting there's inaccurate statements in this record and even today's record. But what is mitigating still in my mind is the going off of what the record states with the review by the DA and Brady considerations and the DPSST staff prior determination that they wanted to remove it. The record was not there for intentional dishonesty. So I think it's a big hurdle for me to get to the point today where I'm going to induce a lot of those things which are going to ultimately impact a lot downstream. I don't think I have a complete picture to do that today.
And Shannon Anderson, for the record, I would agree with that. I think it's important that we talk about it, that we bring it out, but I also don't think there is any extra research or investigation that would bring light to this, that would make it seem more intentional.
Michelle Duncan, for the record, I just think that we need to entertain not just the statements in here. I think that the statements today may bring a new light on that.
So we did, so we brought up the new issue. Do we feel like we've had enough discussion on the third part of this, the misconduct? Affirming, we got a lot of discussion about the adding dishonesty. Not had a lot of discussion on misconduct.
Yeah, Chair Kathleen Comfort, for the record, I think you are at a point if anybody felt that they could at least make a motion to entertain. Again, you can discuss that motion before you second it. But the record that was adopted was they modified and added dishonesty. So, and then now you've discussed that. So I think, of course, welcome to many more discussions, but it also at this point you can make a motion and then kind of get a pulse of where everybody's at.
Robert, for the record, I'll make a motion to affirm the staff, the misconduct allegation. That's what you're asking.
No, I think we've already surpassed that. Erica, correct me if I'm wrong, but didn't they modify the whole thing to add intentional? So you just added the moral fitness, so you guys have already affirmed. So I think you're at the point of now, if anybody's going to make a recommendation to take action or not take action, and then any discussions that follow.
And Chair Noniker, I just wanted to make sure that we didn't miss an opportunity to speak about the misconduct while we were focused on adding or not adding dishonesty. So.
Barrett, for the record, if you want somebody to do that and touch on it, I'm happy to do it. First part of that is about inefficient operation with regards to the evidence that he just stripped. Looking at the old one, so it might be not the same one. He admitted to that in his verbal. He did admit to soliciting prescription medications from people. And then with regards to the creating an inefficient operations of his agency, I think Member Townsend hit on that maybe he was not set up for success in that area with current policies and procedures in place that would then lead to the rest of that, damaging him, his agency's position within that investigation. So I could touch on the first two components of that, but with Member Townsend's input, maybe get rid of the third.
Sure, yeah, and I wasn't trying to complicate things. I just wanted to make sure that we knew we were voting, when we voted to add dishonesty, we were also voting to avert misconduct. So if everyone's in agreement to that, good.
Yeah, so if that's the intent of the committee, we have, we've accepted the staff report with the identified moral fitness and adding dishonesty to that. I mean, that's where we stand. And if we've accurately captured that, then the next step will be, if you want to have a motion to take action or no action, and reminding them, if you do, to explain why.
Michelle Duncan, for the record, I would make a motion to take action based on the totality of this investigation that it is extremely concerning. And again, I can rehash all the stuff that we've talked about, but I think we're good on that.
For the record, I'll tell you that this room didn't like this case back in August of last year. And with the new information, I still don't like it. I think my gut tells me what was going on is accurate. However, to what Superintendent said, we have several other bodies of investigations, different layers on this, that have allowed it to either not be proven to a certain extent, or stuff's not verified, that they're up to including giving him his job back. We would be the oddball saying no.
Shannon and Anderson, while I think that it's within our right and the service that we have to the citizens to be the oddball to say no, I also struggle to come to that we could do that with the facts the way they are, the complications, the policies, the reports, and that this had gone through the courts and they also struggled to find guilt.
Michelle Duncan, for the record, I agree with most of those statements, other than if you take those in different contexts. You have the arbitrator's ruling that confirmed some of what is in here for the misconduct, however, said that he could have his job back based on time of the possession of medication, and two, they weighed heavily on whether it happened during the contract or not. I don't think whether it happened during the contract or not has anything to do with this group. Secondarily, I do agree that the criminal investigation itself, there was not enough evidence because they didn't establish time. Because there was no, even the diversion part, there was no evidence of the actual diversion itself. However, a criminal case does not look at things like dishonesty, and it because they weren't able to consider when he possessed those narcotics. I think the investigation does show that he did so while being a police officer, whether on or off duty.
Chair noting for the record, I'll second the motion to take action.
Right, we are voting on a motion to take action. Chair Nowning?
Aye.
Vice Chair Cotting?
Nay.
Committee Member Anderson?
Nay.
Committee Member Barrett?
Aye.
Committee Member Daniel?
Nay.
Committee Member Jovic?
Aye.
Committee Member Dresser?
Nay.
Committee Member Duncan?
Aye.
Committee Member Livingston?
Nay.
Committee Member Lofgren?
Nay.
Committee Member Rowan?
Nay.
Committee Member Townsend?
Nay.
And Committee Member Wood?
Aye.
Motion failed.
Motion.
That's their committee's choice. Should be an official.
Go ahead. No, we're just
Oh,
telling,
okay.
thanks.
Thank you, Jennifer Howell for the record. So with this was a motion to take action, and that motion did not go forward, so you still do not actually have a recommendation to send to the board. So if you could make another motion and vote for your recommendation to the board. Thank you.
Mark Daniel, for the record, I'll make the motion for official no action.
Second.
All right, voting on a motion to take no action, Chair Nowning,
Nay.
Vice Chair Cotting, Committee Member Anderson.
Aye.
Committee Member Barrett,
Nay.
Committee Member Daniel,
Aye.
Committee Member Jovic,
Nay.
Committee Member Dresser,
Aye.
Committee Member Duncan,
Nay.
Committee Member Livingston,
Aye.
Committee Member Lofgren,
Aye.
Committee Member Rowan,
Aye.
Committee Member Townsend.
Aye.
And Committee Member Wood.
Nay.
Motion passed.
Thank you. Yeah, we probably should take 5 minute break. Oh. Oh wait, hold on, we have to have a discussion about lunch.
Very important.
We can probably be off the record for that. You want to go off the record and have a conversation about lunch?
Thank you.
Would just like to explain that we're moving on to
It's
mechanics.
back on?
Yeah.
Okay, we're resuming our meeting. Our next case is going to be Matthew McCandless, which is
Look through Apps 103.
Yes, it's one of my favorite. Christopher McCandless. Yeah.
We haven't done the sound check.
Yeah.
Yeah, the folks online, just make sure you're with us. Somebody give us a thumbs up or.
Yep, I'm here. I wrote a note in the chat. I'll need to drop off no later than 1 o'clock. I have an accreditation meeting I can't miss.
Okay, thank you. He's somewhere about that. It's not happening, but at least save him all the way.
You have goals.
Good afternoon. My name is Scotty Downey. I'm the chair of the Police Policy Committee. After your case is presented, you'll get an opportunity to give a mitigating statement for 5 minutes. At the end of the 5 minutes, I will cut you off. And at the end, you also won't be able to ask us any questions, and we won't be able to ask you any questions. While we discuss the case after that, you can either sit at the table or you can sit on one of the chairs on the side. It's sort of up to you. And then at the conclusion of your case, you can just exit out the side door.
Yes, sir.
Thank you, Mr. Chair. Melissa Lane Botcher for the record. The department presented Mr. McCandless's case to the May 2024 Police Policy Committee with recommendation for administrative closure. The committee requested the department return the case to the committee for a full review. The department opened a professional standards case for Matthew McCandless to review criminal charges for strangulation, assault 3, and criminal mistreatment. McCandless was also terminated from the Toledo Police Department after the agency conducted an investigation into the grand jury indictment. Mr. McCandless's termination and criminal charges stem from allegations that he caused bruising to his son's neck. After his separation, McCandless was acquitted of the criminal charges, and records in his court case were sealed, making several reports unavailable for the department's use in the review. The department is reaffirming there was insufficient evidence to make a moral fitness violation finding and seeks a vote to affirm, modify, or negate the department's findings, Mr. Chair.
Thank you.
Oh, I'm sorry, actually, this way. And Mr. McCandless is here to provide a verbal statement to the committee, and when you're ready, we will start the timer for 5 minutes.
Thank you. My name is, obviously, is Matthew McCandless. Statement on this, I served 6 years in law enforcement, 8 years military prior with a top secret clearance. I've had no issues with use of force or anger or abuse of any kind. I went through a divorce that was very contentious and have been in a 5-year custody battle that was led to this. Once I got remarried, that's when these allegations came out. I did take a polygraph, which I did see in the report that the investigator said was inconclusive because the questions weren't asked correctly. And the question that I was asked in the polygraph was, did you grab Bubby's, which is the minor, Matthew, my son's neck, while yelling at him in September? I answered no. The result was no deception indicated. Question, in September, did you cause injury to Bubby's neck? Answer, no deception indicated. I've done everything. I was exonerated. I've been honest and forthcoming on all of this. The department did this before I even had my trial. They jumped the gun on this before any of the evidence was presented. There was photos of my son the next day at school with no injuries. We had multiple parties the day I was accused of hurting him. There were no injuries. This has been a nightmare, and I'd like it my name cleared. I did not do anything to hurt my children.
Okay, thank you. Okay, we need to get a consensus to adopt the record or return to staff for additional information. And I've been told there's no additional information. So, available. So, I'm getting a consensus. Any objections to adopting the record as it's been presented? Hearing none. We will move on to aggravating and mitigating factors. Open that discussion.
Townsend, for the record, mitigating that he was acquitted of all charges. Barrett, for the record, also mitigating his verbal testimony to include a very contentious divorce and a 5-year custody battle as mitigating circumstances for this particular case.
Anyone else?
Also, Barrett, sorry, for the record, also mitigating, DPSST staff found no moral witness violations.
Anyone else have any aggravating, mitigating with this case? Hearing none, go ahead, Melissa.
Mr. Chair. Melissa Lane Botcher for the record. I noted that the committee identified as mitigating that he was acquitted on his criminal charges, that his verbal mitigation was mitigating, and that he indicated that he had been in a 5-year custody battle and went through a divorce, and those are circumstances that are mitigating to the case. And additionally, DPSSD did not identify any moral fitness violations. Mr. Chair.
Thank you. Do we have a consensus on her overview, on Melissa's overview of the aggravating mitigating? Further discussion on that? Okay, if not, we'll open the discussion on whether the committee believes there's a moral fitness violation, or if we want to affirm the agency's recommendation that there was no moral fitness violation. We can modify, we can't really negate because they don't have a. We'd be looking for a discussion or a motion. I would make a motion that we affirm, accept as it is, with the understanding there's a lot of information out there that we just do not and will not have access to. So I believe sending it back was the appropriate thing to do last time. They've tried to get additional information, we have what we have. And so I feel comfortable with having taken a second look at it, of just affirming the recommendation of no
Administrative closure.
administrative closure. That's the one.
Yeah.
Those are words that I was looking for. That's my motion.
Rob White for the record, I'll second that.
All right, we're voting on a motion to affirm the staff's record as an administrative closure. Chair Nowney?
Aye.
Vice Chair Cotting?
Aye.
Committee Member Anderson?
Aye.
Committee Member Barrett?
Aye.
Committee Member Daniel?
Aye.
Committee Member Jovic?
Aye.
Committee Member Dresser?
Aye.
Committee Member Duncan?
Aye.
Committee Member Livingston?
Aye.
Committee Member Lofgren?
Aye.
Committee Member Rowan?
Aye.
Committee Member Townsend?
Aye.
And Committee Member Wood?
Aye.
Motion passed.
Thank you. Thank you.
Book one.
Joshua Boner, he's not here. We can roll right into that if we're ready.
When you're ready.
I'm ready.
Okay. Melissa Lane Botcher for the record. The department opened a professional standards case for Joshua Boatner to review the circumstances of his separation from employment with the Silverton Police Department. Boatner resigned from the agency during an investigation that looked at his sharing of agency employees' confidential information that he obtained while working as a captain. He shared that information with personnel who are not entitled to the information. And additionally, the investigation looked at his use of inappropriate language, including the use of derogatory nicknames, accents which were described as racially discriminatory, and voices which were mocking towards persons with developmental disabilities. The department reviewed the records related to Boatner's separation of employment and found conduct that met the Oregon Administrative Rule definition of misuse of authority and misconduct. Finding that his use of confidential information was a misuse of his authority for his benefit, and that his use of derogatory nicknames, accents, and voices created a work environment which impacted the efficient operations of the Silverton Police Department. His use of those accents, nicknames, and voices is evidence of discriminatory conduct, and his disclosure of the confidential information harmed persons by causing embarrassment to those who had their information shared without consent. The department is seeking a vote to affirm, modify, or negate the findings, Mr. Chair.
We look for a consensus from the committee to adopt the record or return it to staff if additional information is needed.
First, Chair, Rob Wood for the record. I need to recuse myself from this as a non-sworn instructor for the Department of Silverton and abstain from all discussions and voting.
Thank you.
Chair, I think we got the.
I think we have a consensus, no objection. Okay, sorry, got sidetracked. Okay, we will open up the case for discussion.
We're doing mitigating and.
Oh, mitigating, aggravating, that's right. That's the one, skipped a step. Aggravating and mitigating, that's what it is.
Yeah, Daniel, for the record, I'll say that there are 2 letters attached to this record, one from Mr. Boatner and one from retired Chief Engelmeyer. Put those as mitigating factors. In fact, Chief Engelmeyer fell on the sword a bit, blaming himself for some of his behaviors.
Anyone else?
Michelle Duncan, aggravating would be just his position within the office, being the second in the command, making these statements and conduct.
Aggravating, Connie for the record, aggravating, as I go back through his DPSST record, I can name a few, but 2022 anti-bias training for law enforcement, 2021 implicit bias diversity training, mentally ill folks in crisis intervention training, and the list goes on. All of those trainings are going to highlight the unprofessional and improper conduct.
Thank you. Anyone else? Aggravating or mitigating?
Figured I'll put this here for the record. I started seeing a trend that's used to describe him as a leader in their agency and how he made them feel. And I almost ran out of paper. Demeaned, attempted to intimidate, uncomfortable, inappropriate, disrespectful, ignorant, detrimental to the agency, immature, lack professionalism, retaliatory, condescending, treated unfairly, and insulting. And that was from almost everybody that was interviewed. Had one of those to say, or more. That's aggravating.
Longren, for the record, I completely agree. I just think there were too many comments that just are very aggravating.
Anyone else? Whenever you get caught up, Melissa, if you could review.
I have as aggravating the letters that Bogner and the retired chief submitted, that were submitted as mitigation, and that the chief took responsibility of some of Bogner's conduct. As aggravating, I have his position at the agency while he was making statements and sharing information. As aggravating, he took bias and diversity training multiple years, which would have highlighted his unprofessional conduct. As aggravating, there was a trend in the words which were used to describe him by the persons that were interviewed that were all negative. And there were too many comments about him that were negative, Mr. Chair.
Thank you. You have a consensus that she covered, Alyssa covered aggravating and mitigating? Anything else to add? Okay. Open the discussion about whether there is a moral fitness violation. We can affirm the two that were identified. We can modify or negate. Scott Young, for the record, I think the misconduct is the easiest. It's clear throughout, as has been already said, in the aggravating multiple individuals who were subordinate to this person were made to feel in a way that's not appropriate at all in the workplace. And so I think the misconduct really speaks for itself. I have no issue with that. The misuse of authority is a little more gray area for me. So.
Fair, for the record, I'm the same with you with regards to the misconduct. For me, misuse of authority is usually something done to gain or to better oneself. I didn't see anything in here that he was after the chief's job or he's after a chief's job somewhere else and is using any of this to go higher up in his agency. The only thing that it would be a stretch is if he's using this to gain the trust of his people that he works with, or to be one of the crowd, and I don't know that that is enough to gain betterment for himself and his agency. So I don't know if that's there for me.
Yeah, for the record, I would agree with Member Barrett. In the discussion, though, he did admit, I believe, that he was still trying to be one of the guys, one of the crowd, and was having a difficult time differentiating himself between management and or leadership and, the rank and file.
Terry Rowan, for the record, I would agree with what's been said so far and add that to me, this looks like a Peter principle kind of a thing where I think he was promoted to a higher level that he just didn't know how to handle. And as Chief said, he was still trying to fit in as one of the boys or one of the guys, so to speak, and which he took responsibility for. In his own words, he said, maybe I just need to grow up some. And yeah, there was quite a bit of negative comments made about him as far as his leadership style and ability. And I'll just leave it at that for now.
Michelle Duncan, for the record. On the misconduct, I think we all agree on, well, I agree with the previous statements. On the misuse of authority, the only thing that I would offer slightly different is he gained this information because of his authority. And specifically, there was harm done by the sharing of that information. And I think the most bothersome to me was the sharing of a potential coworker that was getting hired, and whether she would be problematic based on her sexual orientation. And it sounded like he shared that with other subordinates, and then she was hired, which already put her potentially in a bad light to others. And that was substantiated not only by the comments by a current officer, but also by her when he did the home visit making comments that you look like you're normal. And so I think in that light, I almost see that he did use his position to potentially harm someone's career.
Lofgren, for the records, I would second that in terms of misuse of authority. He did have access to confidential information that he revealed in terms of the medical procedures, childhood experiences, and internal investigations. So to me, that falls under misuse of authority.
Thank you.
Shannon Anderson, it seems like I see that listed under both misuse of authority and misconduct. Is that typical, or is there an opportunity that if it's under one where it fits better, or?
Catherine Calpine, for the record, it's an added one on misconduct. It doesn't stand alone as only that, but it definitely not only in our interpretation, the staff report, misuse of authority as a captain and had access to that, but also how it harmed the efficiency and effectiveness of the operation. So both conducts, you can basically have one thing that fits in both conduct, and that you'll either decide if that's an aggravating, mitigating factor. I think it's within your discretion if you say you only want to put it in one bucket, but that's how we've presented it. We see it in both moral fitness violation.
To cut it down for the record, I think if you read the misuse of authority, a lot of times police officers think about, it being a certain way, but this does say using his position or authority. And after hearing Sheriff Duncan, I would agree. I would make a motion that we affirm the recommendations.
Fair, for the record, can I just get a point of clarification before we do that? Can we just read the full misuse of authority definition that ECOSYSTEM staff has? I could not find it.
Is intentional conduct that includes the use or attempted use of one's position or authority as a public safety professional to obtain a benefit, avoid a detriment, or harm another.
Okay, for the harm another, then yeah, I'm on board with everything that's been said.
Teresa Livingston, I second that.
Thank you.
All right, we are voting on a motion to affirm the moral fitness violations as presented. Chair Nownie?
Aye.
Vice Chair Potting?
Aye.
Committee Member Anderson?
Aye.
Committee Member Barrett?
Aye.
Committee Member Daniel?
Aye.
Committee Member Jovic?
Aye.
Committee Member Dresser?
Aye.
Committee Member Duncan?
Aye.
Committee Member Livingston?
Aye.
Committee Member Lofgren?
Aye.
Committee Member Rowan?
Aye.
Committee Member Townsend?
Aye.
Motion passed.
And we need to have a discussion about, do we take action or not? What action do we take? So I think if you make a motion and suggest a certain amount of time or no time, just give a reason behind your motion. And on this, I think it's important to know the date. I think it's February of, his start date would be, if we took any action, the date of separation, February 3rd, 2023? Yes.
Oh, and Chair, I think our staff has caught that you accepted the report, but now the discussion and the vote is to take action or no action.
Okay. Yes, yes. No, I was letting, I'm sorry. Yeah. Just let him know if we do take action.
Yes, yeah, that's where I was following you and didn't catch that other part. Yeah.
Tight ship around here. If you only wrote it out for me, I would be able to follow it.
Michelle Duncan, for the record, I will vote to take action.
Barrett, I would second that.
All right, we are voting on a motion to take action. Chair Nownie?
Aye.
Vice Chair Cotting?
Aye.
Committee Member Anderson?
Aye.
Committee Member Barrett?
Aye.
Committee Member Daniel?
Aye.
Committee Member Jovic?
Aye.
Committee Member Dresser? Committee Member Duncan?
Aye.
Committee Member Livingston?
Aye.
Committee Member Lofgren?
Aye.
Committee Member Rowan?
Aye.
And Committee Member Thompson? Aye. Motion passed.
Thank you. Chair Downing, for the record, if it would be effective Any action we took will be effective the date of his separation, which is February 3rd, 2023. Our options, should discuss our options. Is this okay at this time?
Yes,
Okay.
absolutely.
All right. Misuse of authority, 3 to 10 years. Misconduct, 3 to 10 years as well.
Fair for the record, for misconduct with the discriminatory aspect, is that not up to lifetime?
That is correct.
But we need to, do we need to discuss that? It was added as an aggravating factor.
It's,
Yes.
It's in,
it's under misconduct, the racially discriminatory accents.
Oh, right, okay.
Yeah.
It's fine. You're correct, 3 years to lifetime. Discussion, motion.
Connie, for the record, I'll just say, after reviewing the conduct, I don't know if I'm quite at lifetime, but I'm certainly at the upper end of this range, meaning more towards 10 years. But swayed their direction.
Fair for the record, I was in the same boat. The behavior is lifetime, but the maturity brings it down for me. To in that 10-year range is kind of where I'm initially starting.
Krista Livingston, for the record, the same with both of you. I definitely would not want less than 10. So to me, it's 10 lifetime. I do agree that the maturity part and the fact that the agency promoted him too fast, and the fact that he admits, that he made some mistakes and that he was trying to be one of the guys. Not that I'm excusing it by any means, just that that part is the thing that's making me go back and forth, but nothing less than 10 in my mind.
Shannon Anderson, I also was thinking 10, and part of that is that there were moments of intervention that were not taken, or were not provided, and so that conduct maybe would not have grown the way it did.
I feel like someone maybe would have a motion up.
Michelle Duncan, for the record, two parts. One, I agree with what has been said, that there's probably a maturity aspect and he took ownership of, he didn't deny making the comments and things. Secondarily, for, I guess, a procedural matter, are we able to, or to vote if that was the way we chose, to go to 10, or do we have to do 3 or 10 on each, or any range in there?
Captain Kaufman, for the record, because you've adopted all the 2 moral fitnesses, it is the range. And because it is the discriminatory, the whole totality can go all the way to lifetime.
So they're not stacking or?
No.
Okay.
Fair, I would make a motion for 10 years.
Shannon, I would second it.
Voting on a motion for a 10-year ineligibility period, Chair Nowling.
Aye.
Vice Chair Conning.
Aye.
Committee Member Anderson.
Aye.
Committee Member Barrett.
Aye.
Committee Member Daniel.
Aye.
Committee Member Jovic.
Aye.
Committee Member Dresser.
Aye.
Committee Member Duncan.
Aye.
Committee Member Livingston.
Aye.
Committee Member Lofgren.
Aye.
Committee Member Rowan.
Aye.
And Committee Member Thompson.
Aye.
Motion passed.
Who's the director?
Yes, but, we'll go on number 9, we can do the applicant review committee nomination. Captain Kaufman, for the record, yes, yes, I will, I want to be very respectful, I know people have some deadlines. The most important thing we need now, as I say thank you once again for sitting on this committee and your time, is that you may or may not know, 2 members of the Police Policy Committee sit on also the Applicant Review Committee. We have Member Barrett, who's currently on it. We did lose Member Gardner when he left. And as the rules state right now, you have to be in your second term to be able to sit on that. If you're not familiar, Applicant Review Committee meets once a month. We sometimes can go 3 months without, but it's very important if we do have one, because these are individuals where they've been hired by their agency, but they have previous criminal convictions, and they need our clearance to be able to attend the basic academy, depending on what discipline they're in. So we do need to fill one representative. If I need to remind you of who is eligible, I'm happy to do that in my paperwork. If those who know they're in their second term and want to jump up and volunteer, I've identified Chair Nowning, Sheriff Brandenburg, who's not here, Kevin Dresser, who's here, Sheriff Rowan, and of course, Member Robwood.
I will say it's not as much reading, so if that's it's not this. The one that we just had yesterday was like 20 pages, 30 pages at most.
And that's a lengthy one at that, but they are very quick but important.
I'm willing to do it.
I nominate Kevin Dresser.
I second.
All right, we're voting. Here we go.
Quick, before we lose it.
All right, we are voting on a motion to nominate Kevin Dresser to the Applicant Review Committee. Chair Nowning?
Aye.
Vice Chair Cotting?
Aye.
Committee Member Anderson?
Aye.
Committee Member Barrett?
Aye.
Committee Member Daniel?
Aye.
Committee Member Jovic?
You might have already.
Oh, anyway. Thank you. Committee Member Dresser?
Aye.
Committee Member Duncan?
Aye.
Committee Member Livingston?
Aye.
Committee Member Lofgren?
Aye.
Committee Member Rowan?
Aye.
Committee Member Townley? Aye. And Committee Member Wood?
Aye.
Motion passed.
Thank you, Kevin, it is appreciated. Thank you, everybody, for the healthy discussion. Resolution. Chair, if I may, on behalf of Director Castle, who, like all of you, has other meetings coming up, the only thing he wanted me to pass along is to remind you that we are all patiently waiting, the state is, for the governor's recommended budget. So we do have some packages on there. I think he's briefed you in the past. So we're anxiously waiting for that. And just a reminder, I don't know if it's because of the end of the year, but a couple of our classes, we do have vacancies. We try to fill all classes if we can. I know some of them have been hunted through the first of the year, but just a reminder for efficiencies, it's nice when we can fill the classes as they come up. And then just as a closure, I have the opportunity along with Director Castle is to sit on the Governor's Medal of Honor task force, and we were able to be present when a Springfield officer, she was awarded the Medal of Honor, and I believe they said it had been like 20 years from the last time they had presented it, and it was very much an honor to witness that and the bravery. So I just want to acknowledge that. And with that, we won't do any other agency updates. We'll be very brief and get you out of here, Chair, with our next meeting in the beginning of the year. So happy holidays to all of you.
February 20th?
February 20th. 10 a.m.
See you. Thank you.
Thank you, everyone. Thank you.
Thank you.